Proceeding will start shortly. The 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 proceeding will start.
Thanks very much, Max, for joining us. As you know, we're the Joint Committee on Human Rights, and therefore we're very interested in the issue of preventing terrorism and protecting human rights at one and the same time. And we're very grateful to you for coming along to talk to us into your new role as independent reviewer of terrorism legislation, which is a role which is very much defined and shaped by the person who's actually in it at the time. So we'll be very pleased to hear from you what you've been doing so far. I know that you've wanted to be very transparent. You've engaged a lot, not least with tweets and speeches, interviews, and also holding consultation meetings. So if you could just very briefly describe what you're aiming to do by this work and how you see it going ahead, very briefly, before we ask you lots of other questions.
Yes, thank you. I'm conscious that I won't be able to describe myself as a newcomer for very much longer. I'm 10 months into post, and with the publication of my first annual report, that means I'm off the mark, however well or however badly is for you to judge. It seemed to me there were two important things on coming into this role. The first was to recognise and to stay within my remit, which is strictly defined in relation to the four statutes which I review: the Terrorism Acts of 2000 and 2006, the TPIM, Terrorism Prevention and Investigative Measures Act, and TAFA, the Terrorist Asset Freezing Act. And so, because as a practitioner I have experience with some, but not all of those statutes, there was a learning curve which I had to undertake. The second thing, which is inextricably linked in my view, is to engage as widely as possible in order to pick up the views of everybody nationwide on the legislation. And all I want to say about that is that it seemed to me, picking up from where my predecessors left off, that both of them, Lord Alex Carlisle and David Anderson more recently, had set the mark at open, frank engagement, going wherever around the country or beyond to speak to anybody who had a view to express on the legislation. I sought to do the same, and in doing that deliberately did not set a bar on what I was willing to listen to, either in terms of whom I should listen to or in terms of the subject matter. And as we may or may not pick up later, that has involved me listening to some forceful and thought-through views on matters that are strictly beyond the legislation. Let's mention prevent for the first time this afternoon, which comes up very regularly in conversation. And I welcome that because it is a route to me understanding what the view and the perception countrywide is about the legislation. But I emphasise at every turn that I'm neither a reviewer of prevent, nor is it my function to change it or to alter it. That is for others. So I can make reflections in the sense of setting out the soundings that I've taken, the community engagement that I've undertaken, the roundtable meetings that I referenced in my annual report, and which are referenced in a previous report brought out by an NGO called Forward Thinking. And I'm very pleased that there are some of those whom I met at roundtable meetings who have come here today to listen to this evidence. It seems to me that I can give weight to their voices because I'm the one giving evidence and not them, but I emphasise that I must, and I hope do, stay within my remit in reviewing the four statutes that I mentioned.
So whilst you stay within your remit of those 4 statutes, would you say that the thing that is most often then raised with you that people feel affected by is the issue of prevent?
I think it's prevent and Schedule 7 of the Terrorism Act 2000. If there's a single sentence that mentions particular factors again and again and again, it is community perception in relation to Schedule 7, port stop, and community perception in relation to prevent.
Okay, thanks. Detta.
I'm very new here. I have never read anything which satisfied my knowledge, or lack of it, on prevent. Is there something that I should be reading?
Well, it is a statutory duty imported by statute in 2015 for certain stakeholders to bear in mind the risk of individuals being encouraged into terrorism. So prevent, which was a strategy on a non-statutory basis until a few years ago, now has statutory form. That takes us to consider the fields of education and health. There is guidance published by the Home Office on how prevent is to be conducted around the country by different stakeholder groups. But none of that has statutory force under the Acts of Parliament which I review, which is why there is a detachment, a proper detachment between my function and prevent through the Home Office.
I have to say it's very helpful.
Thanks.
Karen.
Sorry. Karen.
Very much. So the report acknowledges the fact that Daesh and Daesh-inspired terrorism remains the single biggest threat. But you talk in the report about the trends in terrorist violence inspired in Ireland.
Yes.
And also you refer to, I don't think you go into that much depth, about the trends in far right violence. And I just wondered if you could tell us a little bit about where you see those emerging trends, and whether in our approach to this issue we are that there is any downside to the fact that the current terrorism debate does tend to focus very largely upon Islamic terrorism.
Yes. Thank you. I think I give a very standard lawyer's answer, if I may, which is that terrorism, as defined under Section 1 of the 2000 Act, mentions religion, but mentions no particular religion or sect within a religion, nor does it mention territorial boundaries, from which the first fundamental point to be made is that terrorism, in its definition since 2000, has application worldwide. And I mean worldwide because in later statutes the territorial jurisdiction of UK terrorist offences has been extended so that we are able, for example, to prosecute in relation to activity beyond this country as well as here. If I may say so, I think that you are also extremely accurate, and more accurate than many, in using the phrase Daesh-inspired terrorism, where many other commentators use the word Islamist terrorism. It is fundamentally wrong to attach the word terrorism to any of the world religions. To put that another way round, those who adhere to any of the great religions or none can be terrorists within the Section 1 definition. So it is necessary to look across the whole piece. And as a prosecutor of many years' experience, which was the only basis on which I think I had any attraction as being a possible successor to David Anderson, I have spent significant periods of time prosecuting in non-Daesh inspired, non-AQ, non-Eastern or Middle Eastern terrorism. And the phenomenon of extreme and far right-wing terrorism is nothing new. I think if I may pick up on your question, I would suggest that we are not necessarily seeing the emergence or the creation in 2017-18 of new extreme right-wing terrorism where previously there was none. What we are seeing is an increased detection and increased reporting of violent extremism from that quarter, which I recognise because I used to prosecute it many years ago. I think that going back only for a moment to community engagement, one of the great myths which is often repeated to me is that by definition and by application, we, the UK authorities, of which I'm not one of course, deal with only a segment of the community and only a certain species of terrorism. That's manifestly wrong. What has happened, though, during 2017-18, and I tried to deal with it in my report, has been a spike, a rapid increase in incidences, in particular, of Islamophobia, because of the nature of some, but not all, of the atrocities on our streets last year. And we're seeing a very troubling spike in Islamophobic activity, which, even more troubling, does not seem to be returning to the same base level after each and every spike. So that is an alarming development. But as I say, in part it's because there's more reporting, more awareness, and more coming to the attention of the police, allowing them to intercede. Yes. It's their function to intercede right across the spectrum.
Thank you. We're going to ask you a number of questions on Prevent, and I don't want, if you don't mind, to answer this question too broadly, but you said in your opening remarks that Prevent and Schedule 7 were the main issues that were fed back to you in consultation. Do you find, in respect of Prevent, that you are getting responses from within communities around the extreme right-wing terrorism that you refer to? And I say that because I think, looking at the last Prevent figures did indicate a really quite sharp rise in Prevent referrals relating to right-wing threats. Yeah. Is that something you had any feedback, or has the feedback on Prevent been very largely within Muslim communities?
I think that when I attend Muslim communities, and I should say I'm been very grateful to be made so welcome, whether it's in Manchester, Bradford, Leicester or London, the predominant concern, which is voiced both with regard to the legislation and the Prevent policy, is one of isolation. Sometimes the word used is segregation, sometimes the phrase used is top-down imposition onto communities, disenfranchisement of communities who want their own voice, want to be regarded as part of the solution and not wrongly as part of the problem. So all of that, in terms of the views that are expressed to me, comes from an understanding, and it is often a misunderstanding, of the intention both of the legislation and of Prevent. Secondary to that is the sheer backlash from Daesh-inspired events that results in a spike in Islamophobic activity. It is absolutely right that in some of my engagement, not all of which involves travelling around the country, I think of Tell Mama, an NGO which I name in the report, who keep their own records on report to them of hundreds, in fact thousands of Islamophobic events, and that is where my answer in relation to spikes in activities come from. So yes, it is a particular concern. I think the other thing I would say is that there is, and why should there be, but there is perhaps little appreciation in some parts of the community and some communities around the country that Prevent can apply in non-Daesh, non-Islam-based situations, because those in, let's say, Muslim community, the Libyan community in Manchester, don't tend to see that. And that means that we have some distance to cover in making it plain that, in my case, the legislation, in the case of others who are concerned with Prevent, this is all intended to deal with problems from wherever they arise. Okay.
Last question. David Anderson, in his last report, referred to the fact that at that point there was it was notable that the number of terrorist-related incidents was not as great as might have been expected, given, and he quoted the reputation of London as being the jihadi subculture capital of the world. I wonder what you thought of that, and whether there is any sense in which a town, whether it's a city, whether it's London, Luton, Leicester, any other place, having a label of this kind is helpful or unhelpful?
Well, it's plainly unhelpful for there to be a perception that in one particular city, in one country, we are living in the centre of a jihadi-based culture. I would suggest that more recent events have demonstrated that that is not entirely accurate, which isn't to say that I disagree with David and his appreciation of slightly earlier times. But what happened, and it was a fundamental shift after the declaration of the so-called caliphate in July 2014, is that led to a problem which in particular is Western Europe-wide. It's not in relation to the United Kingdom only, still less in relation to London only. What happened was that the previous perception of living in a state of stability, albeit in a foreign land, brought with it a covenant of security, often quoted, has been swept away as a result of propaganda coming out of what would have been Al-Qaeda territory, but is now so-called Islamic State territory. And the fatwas, which they're called, although they aren't, because I haven't seen anybody with any authority to administer a fatwa operating under so-called Islamic State. But when those fatwas have been administered, they've been to the effect of giving a new message and saying, yes, you're still welcome to conduct hijrah, to emigrate from your country to a land where Islam thrives, namely Syria, but you no longer need to do that. If you can't do that for whatever reason, you should plot and plan in your country of domicile. That is very different to the picture that we faced a decade ago, where people were travelling for terrorism, but were not planning to commit it here. Yes, we are seeing, therefore, an increase in actually low sophistication, suicide-based attacks, sometimes with knives, sometimes with crude improvised explosive devices, which are utterly lethal, witness Manchester Arena. But we are seeing that in Paris, we're seeing that in Brussels, we've seen it in Madrid, we see it in the cities in Germany. So I would move away from any suggestion that London is the centre. London, being part of this country, being situated in Western Europe, has a problem which is common to many other countries. It's then down to individual legislators and executives to decide how to deal with it, and there are some variations between the way this place deals with terrorism in this jurisdiction, the way it's dealt with and addressed in France, and indeed the way it's addressed in Germany.
Okay. Thanks. Detta.
Sorry. Where was I? What number is it? Number 4, thank you. Right. Yes, this is prevention and freedom of speech in universities. Your report notes that while Daesh presented the most significant terrorist threat of North...
The next one.
Oh, sorry. Right, okay, prevent freedom of speech in university. In our inquiry into freedom of speech in universities, we had a sharp disagreement between witnesses about the extent to which exposure to radicalism was a university problem. We note that the most recent statistics on prevent referrals shows the highest number are aged 15 to 20. The second highest were those under 15, and that 33% of referrals came through the education sector. Is the government right to be concerned about higher education institutions?
Well, I preface my answer by repeating that I'm not influential in respect to prevent, nor is it within my remit. But to try to assist, what I realised in my community roundtable meetings is that there is great anxiety around the country about the application of the statutory prevent duty, in particular in the way that it impacts in education. I would add to that I don't think, from those who've spoken to me, that it is restricted to higher or tertiary education. Much of the impact that concerns people is in secondary or even primary education. And we're all familiar with the examples of actually very young children who find through their parents that they've been reported to prevent officers because of a childish sketch in an art class at primary school and a fear on the part of the teacher that there may be some reference to terrorism. So my soundings suggest that in the field of education there's actually broad impact and broad consequences if and to the extent that the statutory duty to safeguard individuals against encouragement into terrorism is not rolled out, is not deployed in an effective fashion. I don't say that it is being done ineffectively, nor do I say, because it's not for me to say, whether the resource that is applied is effective, leads to efficiency. But I am bound to echo those voices who've said to me that in the education sector it is a matter of concern just as much as it is in the health sector. I think I would add to that the soundings that I take, of course, are by no means only from community roundtables, be it in Leicester, Bradford or Manchester. When I take soundings, I will also do that from prevent officers, police officers in the Metropolitan Police or elsewhere, who are charged with this duty and who do attend mosques, other places of worship, community centres, family homes, schools and hospitals in order to carry out their duty. Often what's expressed to me, actually within senior levels of Metropolitan Police, is that prevent with a small p is something that policing in this country has been used to deal with over many decades. They would tend to use a word beginning with an S, namely safeguarding, rather than a word beginning with a P. But they recognise that that is part of the function of effective policing, just as, in order to deal with terrorism in whatever form, solutions that come from general policing rather than bespoke counter-terrorism policing can be of great utility. Example, lessons learned from gang culture, drug taking, group activity by rootless individuals on the streets can also be deployed in terms of drawing individuals back who, without encouragement in the right direction, might be drawn into terrorism. So I think the picture is quite complicated. I wouldn't want it to be thought that it is my view that prevent is inaccurately being applied in education. But to answer your question, the concerns expressed to me are not restricted to higher education. They're more broad than that.
I see. Thank you.
Thank you. Harry.
Focusing on the concerns you've just been referring to, is a part of the problem determining what constitute extremist views? And what have you any comments you'd make about that?
Thank you. Yes. Reverting to being a lawyer in answering a question from one of our most senior and experienced lawyers, I think that it's of fundamental importance to distinguish the terminology. It is unfortunate that extremism, and I'm not saying anyone's to blame for this, but it's unfortunate that extremism is a word that is deployed in relation to the new Commission for Countering Extremism, and is something which the lead commissioner now appointed has to deal with. And extremism is also a term of art in relation to violent terrorism, which we deal with in our courts. I go back to the Section 1 definition. We know that the threat or use of violence on the basis of the background causes that we know about from the Section 1 definition is terrorism. And our legislation, rightly, if I may say so, concentrates on dealing with violent extremism, both in the commission of activity and at the preparatory stages for activity.
Yes.
And we could talk about discrete offences in that regard. The shift that we've seen in the last year or two has been to, as it seems to me, move away from legislating against non-violent extremism. That is possibly a positive development, and move into a commission, but a commission that is going to need to define its territory and therefore to define what extremism is. It's not for me to define extremism in the terms of the commission, but I'm absolutely sure that whatever definition is settled upon, it will and must be different to the Section 1 definition of terrorism that we deal with in our criminal courts. And I'm very interested, from the point of view of remit and the point of view of avoiding confusion, to ensure that there is clear water between the two. So there's a very real task to be undertaken by the new Commission, but they're not legislating. What I'm dealing with is that particular space where the threat that is present from threat or use of action in the name of extremism as defined under Section 1 is what our courts and police are dealing with.
And that's, so you I think is inherent, correct me if I'm wrong in what you're saying, is you recognise that there can be different degrees of observance in most religions.
Certainly.
And to some, what a particular view of the right requirements of the religion would be described to the onlooker as being extreme. But you're saying that they should not be necessarily assimilated with the sort of extremism which can result in violence.
Yes.
And I think you're making a very clear, in your approach, divide of that sort. Is that taking place now?
Yes. I mean, I think some of the discussion we had around the countering non-violent extremism process which the government was engaged on hinged on the notion that there was an escalator which started with conservative Islamic religious views and then went on to extreme conservative Islamic religious views and then went on to violence. And there was an argument from some that actually you could have very fundamental Islamic religious views of extreme conservatism, but actually not at all be likely to break the law in any way, shape or form, and challenging the notion of that kind of escalator which seems to lie behind prevent. It's that point, really.
Yes, in a sense we're on the edge of my territory, so I need to be careful. But if I take an example which is firmly within my territory, the offence under Section 12 of the Terrorism Act 2000 of encouragement of terrorism, of which one notorious individual, Anjem Chowdhury, was convicted recently, is more than the expression of a view, is more than thinking in a particular way, whether you call that religious conservative views. And of course, in parenthesis, there can be conservative views about every religion. It's not merely Islam. That is not the target of Section 12 of the Terrorism Act 2000. And the judge who tried the Chowdhury case was very clear in his sentencing remarks that it wasn't just what Chowdhury said, it was what he said in his position of particular knowledge as to who was going to receive that message. In other words, speaking with a particular audience in mind, whom, as I would paraphrase it, he knew were likely to be spurred to particular types of violent action by his words. That is why he was guilty and sentenced to the Section 12 offence. And so looking at it through that prism, we can see that it's not merely holding a view which others within your religion or in any other religion might disagree. It is then taking steps. Put that another way, it's thought with action.
Could I take,
yes,
as an illustration, following what you're saying, from my own experience as a Jew? There are members of the Jewish faith who feel that it would be quite wrong to press a button on a lift rather than climbing the stairs. On the other hand, if the lift worked automatically, stopping at each floor, they could take that.
Yes.
But now, to me, that would seem to be a very clear example of extremism, but it's got nothing to do with the field that you're focusing on. Is that correct? Or?
That is correct. And of course, in those cases that you are thinking of, Lord Wolfe, it's not impossible, but almost unthinkable that those who hold an extreme view in terms of how to move around a building would go on to commit or even to contemplate acts of violent extremism. So I'm glad you've used the lift analogy, because it allows me to say that the elevator analogy really doesn't work when subjected to a moment's scrutiny. But doesn't mean to say that those who start by espousing conservative views in relation to the religion of their birth cannot go on to commit violent extremism. Any of us can. Fortunately, very, very few do. But to suggest that an extreme view, an extreme way of thinking, is an elevator in every case, or even a substantial number of cases, to extreme action, isn't right. And whether it's a good example or not, the Chowdhury case is interesting because we have an articulate, educated individual who knew the boundaries of the law. We hear that there were multiple attempts to see whether he breached the law. Ultimately, he plainly did. Was correctly charged and convicted under Section 12. But it wasn't in relation to what he may have said or done years before. It was in relation to particular aspects of his speeches with a targeted audience in mind, which allowed the court, and it's a jury of course, to recognise that here was an individual who had only one thing in mind, and that was the commission of terrorist acts. And of course, when terrorism is mentioned on any occasion in a criminal court, that can and only means terrorism as defined under Section 1. To simply say something that many of us would disagree with is a very large distance away from satisfying the Section 1 definition, or indicating that non-violent extremism will morph over time into violent extremism.
Thank you. Sally.
Thank you, yes. The government's review of its counter-terrorism strategy and remaining largely with PREVENT, but anything else you might want to say. Are you involved? Have you got any clues you can give to us about what the government is thinking as to what is effective? We've talked about PREVENT being effective, and if you would like to share views about what effectiveness means, including confidence on the part of the community and so on, we'll be glad to hear them.
Yes. Can I answer that in two parts? Because you refer to, of course, the Prime Minister's speech on the 4th of June, which I listened to with interest along with everybody else. In terms of the delivery of the PREVENT strategy, it's necessary to have a strategy. It's necessary to effectively deliver it. It is not for me to say whether it's currently being done effectively or not, although I am concerned to hear from many of whom I've spoken to that they express a lack of confidence, which should sound alarm bells, and it's for others to make sure that that confidence returns to a strategy which has correct aims, which is intended to deliver something for good, and which should be given a chance to grow in the way that the government, and to the extent that they are now involved, the new Commission, are responsible for it. But in terms of the actual review of the strategy as announced on the day after the London Bridge attack, if I may answer your question on that, of course I am not directly involved. I am not the author of what emerges from that review. But as you would, I hope, expect, I've had unfettered access to what is being discussed around the table. I've observed at a Home Office level, because they've been superintending the review, as it were, on behalf of Number 10, that multiple departments are involved. It has provided, I would suggest, a welcome opportunity for anybody involved in the delivery of investigation and prosecution in the field that I'm concerned with, an open, several months long window to reflect on what we have on the statute book and what we may want on the statute book. I think, but I don't know, that a counter-terrorism bill is likely to emerge in the near future. I would expect, though I do not know, that there will be a number of proposals in the bill which look again at offences that are already on the statute book, look again at the effectiveness of those offences, bearing in mind the modern world. And as I've said at one stage in this report, the telecommunications possibilities and infrastructure in 2000, when this place passed the 2000 Act, have changed over the last 17 years in many ways that we know about. Just thinking of the capacity of the devices we use now as opposed to 17 years ago. So there is a question of application and efficacy of the offences over the passage of time. And that is welcome, provided that in restructuring or redefining any of the existing offences, the necessary norms, which are best expressed under the European Convention, the fundamental rights that we all enjoy, are not inappropriately interfered with. And I can expand on that later if you would wish. I think the other aspect, which is partly passage of time as well, is that the sentencing powers of actually those few experienced and senior judges who deal with terrorism cases is capable of helpful review. I've given an example in what I've been able to reduce to writing of the offence of assisting an offender under Section 38 of the Terrorism Act 2000, which, as we know, can be committed before the Principal Act or after the Principal Act. Very serious, I would venture to suggest, indeed, where somebody, however closely connected to a principal offender, knows that that person may be about to go on to commit, at its worst, the sort of act that we saw at Manchester Arena a few months ago. And yet the sentencing power at the time of the 2000 Act was limited to a discretionary maximum of 5 years imprisonment. I would beg to question whether that is sufficient as a discretionary maximum, and I wouldn't be surprised if in a forthcoming counter-terrorism bill the government set out an intention to increase that. Where I've had the opportunity to consider that and have written about it even before the strategy review, I've made the point, which I would stress for your examination, that it should only be an increase on the discretionary maximum sentence that a court may impose. I am not, if I may say so, in favour of minimum mandatory sentencing. That is not to undermine minimum sentencing in some other areas. Repeat offences of burglary, let's say, been on the statute book since the beginning of the century. Offences involving the possession and use of a knife, where a minimum sentence applies. Minimum sentences for carrying a firearm. I have absolutely no argument with any of that. But a minimum statutory sentence for committing an offence of assisting an offender strikes me as a discourtesy to these very senior judges who know what they're doing, who are specifically authorised to try these cases, and also carries the possible impediment of visiting on individuals who are at the bottom of the spectrum, even though they may have committed the offence, the same as those at the top of the spectrum. That is why a discretionary power is what is needed. But I think there are examples where a higher discretionary maximum may be appropriate. And although it's not my purpose to talk about individual cases, the Chowdhury case, which I've already mentioned, might be a case in point. We know that some commentators were surprised at the sentence that he received, given the gravity of his offending. But the judge applied the statutory maximum, discounted in the various ways that he's enjoined to do, and it seems to me there's an argument for a higher discretionary maximum. What that leaves, if I may, is the question of whether, if there is a counter-terrorism bill this year, there are any entirely fresh terrorism offences. And on that, you may have other questions later, I've been at pains to say that it seems to me we already have a patchwork quilt, and it's a pretty big quilt of existing terrorism offences. And if I may say so, even with my experience as a prosecutor over many years, I'm struggling to identify any completely fresh offence that is needed. What I'd add for your consumption is that absolutely is my view if we were to see a proposal for a fresh preparatory or precursor offence, if that threatened the fundamental rights and freedoms that I mentioned a few minutes ago. In other words, if there was an attempt to draw back from the existing precursor offences, which all require thought or mindset plus action, into legislating against thought alone, then I would have great difficulty in seeing how that could be correctly applied and how it could be effective. So I think there are a number of things that could come out of the review. I have absolutely an inkling of what's under discussion, but I don't know, because it's not a matter for me as to what will come forward.
Well, thank you. You've answered one of the follow-up questions I was going to ask, which was about any new offences, because you made your view about not adding lots to the statute book known quite early on, I think, in your incumbency, if that's the right term. Can I just ask, Chair, do you think your role should be, and your remit should be expanded now that you're a little way into the job?
I'm certainly not asking for that. And if I may say so, I have more than enough to do in trying to cover the 4 statutes. I mean, I think if we go on, as we may, to discuss the sanctions bill, I do have a view on the impact that may have on remit, and I'm happy to take questions on that if there are any. But I'm not looking to expand into other areas. My interest is in domestic counter-terrorism, in the way that we deal with that through statutory vehicles and bringing people before the court. And it seems to me that I already have sufficient latitude to review and to comment essentially on the whole output, which is why I was at pains to try to include a chapter in my annual report on the significant cases that were concluded in 2016, from which you can see, and it's a selection only, but you can see the breadth of activity that is already being brought before the court. And I would just add that my views on whether we need fresh offences should not be interpreted as any weakness in the face of terrorism, any rowing back against the robust laws that we need. On the contrary, it's my experience that we have those offences in place. And by the way, as I know you recognise, many of those offences are ones at common law or in other earlier statute, which are still the choice of prosecutors, as it used to be, like me, where I would tomorrow indict an individual who committed a murder in the name of terrorism under the common law for murder, and I would indict an individual who committed an offence using improvised explosive devices under the 1883 Explosive Substances Act, because those offences work. They're of real utility, they're of practical use to prosecutors. We don't have to put a legislative label of terrorism in the name of the statute, provided we all recognise that we know what terrorism is when we see it. And therefore the murder of a member of this place, Joe Cox MP, was undoubtedly, unquestionably terrorism. The fact that the perpetrator was rightly tried and convicted and sentenced for murder makes him no less a terrorist. He undoubtedly was, just as the killers of Fusilier Rigby in Woolwich were terrorists, but they too were charged with murder because it wasn't necessary to construct a special statutory offence for them.
Thank you.
Okay, should we just go slightly out of our order, since you've mentioned the sanctions bill, and go to Fiona, and then we will dive back via Doreen to Schedule 7 and the issue of ports and borders.
Yes.
Thank you, Chair. Good afternoon, Mr Hill, and thank you for saying you're happy to take some questions on the sanctions bill, because we have some about the proposed threshold change and also about your oversight powers.
Yes.
So my first question is that under the current law, ministers can impose terrorist-related sanctions on individuals if they reasonably believe they've been involved in terrorist activity. But the sanctions bill would replace that threshold of reasonable belief with a lower threshold of reasonable suspicion. What, in your view, are the implications of this, and what do you think the threshold should be for the imposition of terrorist-related sanctions?
What I'd say about it is that we've seen in the debate and scrutiny, and indeed in correspondence with ministers, that they rightly point to the existence of a reasonable suspicion threshold in other European jurisdictions, and therefore they rightly say that applying a new sanctions regime with designation for reasonable suspicion will not meet with criticism from Europe. Does that mean that it was necessary to fall back from belief to reasonable suspicion? if I may say so, I think that is a very good question. It doesn't strike me as being necessary to fall back from the high watermark that we'd established in this jurisdiction, bearing in mind that much of the legislation that you make in this place actually forms a template for other countries to follow. It's not so much the other way round. And the fact that reasonable belief used to be the standard is a matter of some regret on the part of many commentators that we've fallen back to reasonable suspicion. It's true that it's in common with the state of mind of the investigator, officer, whomever it may be, or indeed minister, in other areas concerned with the legislation. So there's an argument that there has been a levelling of the field by bringing the sanctions designation test down from reasonable belief to reasonable suspicion. In my discussions around the country, many are confused as to what reasonable suspicion amounts to. There would be enormous concern if it were thought that reasonable suspicion simply meant that for almost no reason a sanctions designation could be made. That's plainly not what the government intend. There are other aspects of the bill which I think excite comment, which perhaps we'll turn on to, but my answer in short is that reasonable suspicion is understandable, but to a degree regrettable when we had advanced to a standard above that, which, had it been possible to keep it, would, I think, from the lawyer's perspective, have been very welcome.
Thank you. Now, under the current law, you have a statutory duty to report annually on the implementation of the Terrorist Asset Freezing Act. The Sanctions Bill would remove your oversight of terrorist-related sanctions without apparently a replacement of some alternative independent oversight mechanism. What's your view on this?
I'm very glad you've asked that, because one of the many things in preparation for coming here today was to consider where we've actually reached in terms of the sanctions and money laundering legislation. My take on it is this, and I hope I'm right, and I hope I'm not wrong, that in the first place it is necessary to legislate because of the consequence of this country leaving the European Union. And I understand that. It was explained to me very early in this role that the imposition of sanctions, whether terrorist asset freezing or more broadly, needed to be put on a fresh statutory footing because of the EU cutout, if I can put it that way. So I understand that. Given that the new regime is far broader than terrorism, and that the sanctions and the designations that fall under the new bill are far broader than terrorism, I can also understand that in the draft bill there is no reference to my remit, because I would not expect, nor would it be right, for me to review the entire sanctions regime. My focus, as I said in answer to an earlier question, is exclusively on counter-terrorism, and particularly domestic counter-terrorism. So on that basis, I can understand why the draftsman of the bill left me out in terms of review and remit. However, I'm not sure that it is the intention of government to leave me out when it comes to review of those sanctions, provided the bill goes through, that are terrorist designations.
Yes.
And I'm in conversation and indeed correspondence with Home Office, Foreign Office and Her Majesty's Treasury. I'm reasonably confident that there is in fact no intention to remove my review of any measures that relate to domestic counter-terrorism, and I am awaiting a suitable solution to make it clear that I will still have the power to review sanctions designations where they are driven by concerns as to terrorism-related activity. So it's too soon to be certain. It is something that I'm looking at and that I'm entitled to look at, and I believe, as of now, that the right answer will be arrived at, because it would be the wrong answer, in my humble opinion, to say that my review and remit, which already covers financial sanctions of different sorts, remembering that there are terrorist financing offences in the other statutes which I review. So I'm already engaged in, to the extent that we intercede with financial measures and financial prosecutions, be quite wrong for the effect of this new legislation to say that in this pocket, this area of activity, I'm now suddenly barred. But I don't think that's what government has in mind, although I entirely agree that looking at the black letter of the draft law and even looking at the correspondence that I've seen, no solution has yet been provided, perhaps to your satisfaction. May I say, neither to mine, but I think there's an intention there.
Thank you for that very comprehensive reply. Just my third and final question, briefly. Your predecessor, David Anderson, has said with regard to the Terrorist Asset Freezing Act of 2010 that exceptional powers require exceptional safeguards. Do you think that the safeguards in the sanctions bill as currently drafted are sufficient?
Well, my answer to that would be to draw focus, which I hope is at least part of what you intend, on humanitarian and peacekeeping work and exemptions and licensing, which is an important part of this area. I know that following my predecessor's recommendation in his own reports on the Terrorist Asset Freezing Act, that there is a working group, I think under the superintendence of the Home Office, in which many of the lead NGOs in this area are directly engaged. They are meeting with a view to finding solutions so that the new sanctions regime does not operate against what we could all agree is necessary and continuing humanitarian and peacekeeping activity. Quite how those solutions are going to be found is clearly a matter of detail. When I have met with leading charities and other NGOs, which I have recently, they've pointed to their own input at the bill stage. They've expressed the need, which I, if I may say so, entirely understand and endorse, for safeguards for their work. I think that they, at the moment, are anxious lest any support seems to be ex post facto or piecemeal, because we can all understand that a humanitarian project may involve any number of ventures, may involve more than one jurisdiction, may involve associating with multiple state actors here and abroad, and unless in advance there is some general license that can be provided and assurance provided for those NGOs, the valuable work and resource and input into the project could fall at a late hurdle, right, and that would be counterproductive.
Yes.
Beyond that, I can't go because I simply don't know the level of detail. But knowing as I do that David's reports into the Asset Freezing Act were fueled by his own personal experience on being invited to visit NGOs who were in the course of humanitarian projects, I've volunteered immediately to do the same, and I look forward to being able to do that. And I hope in the meantime that their expressions of this need for exceptions and licences, specifically for humanitarian and peacekeeping work, are not forgotten. I'm sure the government won't forget, but this is something that needs to be worked through.
Thank you. Thank you, Chair.
Could I just follow up to Fiona's first point in question in relation to your oversight? You'd expect, presumably, that the reassurances that you think that you've got the oversight into the terrorism-related issues in the sanction bill would be in the statute, not just be in a reassurance or in minutes of a meeting or in a letter. I mean, presumably, if everything else you do is laid out in the statutes that you cover, you would expect it to be in the same form.
Well, plainly, I'll go so far as saying that where my remit in all other respects is a matter of primary legislation, it would be most convenient and most welcome for there to be a confirmation of my remit in this primary legislation. That's not to undermine my understanding, as I was trying to express, sure, that for the broader sanctions regime,
sure, we've got that.
I wouldn't come to mind. But
well, fortunately, we've got members in the Lords and the Commons, which will no doubt be all over this, I feel sure. So let's turn to Ports and Borders and Doreen then. We're just doubling back onto
Okay,
searching, stopping.
You have recommended that there should be a reasonable grounds to support the exercise of Schedule 7 powers. What difference would this make in practice, given that the Code of Practice already say that the decision to select person for examination must be arbitrary? And why do you consider it necessary? Should the committee be concerned by the numbers of people of Asian origin stop under Schedule 7 powers?
Well, plainly, this is a huge topic, one of great concern, and if I may say so, one of the areas on which there is confusion about the power, what it's there for, and how it is exercised. My proposal, which I'll come to, in part, if it were acted upon, would cure confusion, would move away from the perception of random stopping or stops based on ethnicity alone, both of which are amongst the things that have been expressed to me when I've gone around the country. I, of course, can say, which is true, taking it from the Code of Practice, which you've accurately quoted, that there is no such thing as a random border stop, nor is there a stop based on ethnicity alone, because ever since the Begal case, the Code of Practice has been amended to make it plain that that shouldn't happen. Does that mean that we simply stop there? No, in my view. I've watched over several annual reports where my predecessor has advocated reasonable grounds for suspicion, which is a legal term that we can all grasp. And I have seen the government, for reasons that it's stated over the years, refusing to import that. I had to make a decision on whether to repeat, as I could have done, what my predecessor had advocated. It seemed to me that there is, if I may put it this way, a stalemate on that issue, but we shouldn't remain static. In areas of practicality, if I can come to that, the question I ask is how much more difficult it would be for an officer who is already adhering to the Code of Practice, as he or she must, to make a brief record to indicate how he or she has adhered to the Code of Practice. And although I appreciate that thousands are stopped, some for very short periods of time, some for up to 6 hours, and I appreciate that paperwork in every case can multiply, it doesn't seem to me that it would be too onerous for ports officers to make an entry to indicate on a device or on a piece of paper that the particular stop that is under question was undertaken because of the following factors in the Code of Practice. Code already says you will not stop for ethnicity alone, you're looking for other indicators. How difficult would it be to express that? If that could be done, and I at the moment can see no reason why it shouldn't be done, that would provide a robust or a more robust answer to those who believe that ethnicity alone is enough. Having said that, you're quite right to point to the disproportionate number of citizens of this country who are Asian as opposed to white, who are stopped. As I've said, and as I think some are perhaps surprised to realise, and there have been when I've gone around the country, actually, at the point of stopping, there are as many white people who are stopped at borders as there are Asians. They're within 1% of each other, 28% to 29%. But, as of course you, Baroness Lawrence, would immediately point out, one has to look at the proportion of the national population, and we know that that does mean there are disproportionate numbers of Asians who are stopped, even though the actual head count is the same. And we know that when those stops turn into formal detention of up to 1 hour or going up to 6 hours, there is a greater disproportion. Those difficulties in perception of the legislation would in part, I'm not saying in whole, but in part be swept away if we could have a demonstration of the basis on which a stop is conducted. And reasonable grounds to support struck me as something that would be a move in the right direction, but I don't wish to distance myself from my predecessor, who rightly said that we should strive to achieve reasonable grounds for suspicion, which is the test applied in so many other statutes and should be applied here. So I wait with interest to see what the reaction will be. The final thing I would say, though, in terms of the disproportionate effect of Schedule 7 in relation to the Asian community, is that that is in part understandable. We can't simply take a statistical view on this. May I give an example? On going to sit with the Libyan community in Manchester, which I have, one of the things that was expressed to me was a concern that a Libyan-born UK citizen who chose to fly to visit his or her family back in Libya was going to be stopped disproportionately frequently merely because they were flying to Libya. And the view expressed to me was, that is wrong, it shouldn't happen. I'm afraid the answer I had to give was, it may be wrong in some cases. That is why reasonable grounds to support would allow us to work through the proper application of the power. But in other cases, it wouldn't be wrong. And the reason I say that is that where the police know that dedicated terrorists have used a particular route to travel and have been in the course of planning an atrocity when they have travelled, and that applies to Abedi, the Manchester bomber, those who take the same route must anticipate, must expect that there's going to be greater attention on the part of the authorities to those routes. So it's not a case of simply saying you will not be stopped. The system is much more sophisticated than that. We already have the code of practice. We also have the level of discretion that ports officers use. We know that in many instances there's very little discretion that is applied to a stop at the port itself because the individual is a designated subject of interest and there is in effect an instruction to stop that person. There are other cases where an individual may not be a subject of interest, but where, by careful application of the codes, there may be one or more features of that individual's travel, which can include their behaviour, can include the route they take, which justifies a stop. And so for the Libyan community in Manchester, and because of what happened in Manchester Arena, up to a point they must expect a degree of interference. Wouldn't
that come under around intelligence? Because I mean to say, if you have, we're talking about the Manchester and the Libyan, that would come with intelligence, which is what I feel at times that should be used to override the arbitrary sort of stops, wouldn't you say?
Well, I think the counter-argument to that on behalf of the Ports and Border Police would be that intelligence, of course, must be used in every case where it's available, but they would point to instances where, in the complete absence of intelligence, a correct stop has been made. In other words, violent extremist material has been found on a laptop, on a mobile phone, on another device, even though there was no intelligence to suggest that this individual traveller would have that material. And the effectiveness of this gate stop, I often use the medical word, this triage system at point of entry to the country, can't be too greatly understated. There are known examples where criminal charges under the terrorism legislation have followed on from a Schedule 7 port stop, either because of a breach of the statute in terms of providing access to devices, which is an offence of itself, or because on provision of the device it transpires that there is a violent and extreme material on that laptop, which must be charged, must be prosecuted. So I give credit to the police because they're experienced in this area when they argue that we cannot draw back to intelligence-only stops. Where I challenge them is in the non-intelligence cases where, given the position we've already reached under the codes of practice, I argue that they should do a little more to verify and to justify the stops. Because if they don't, the perception by many that it's random will perpetuate, will not be answered. And what we're interested in is a robust system which is necessary, but which is at no stage used on a random basis.
I mean, you were meaning, weren't you, drawing intelligence in relation to, like, for example, the routes?
Yes. Not
necessarily intelligence in relation to the individual, but that was a very helpful answer.
Well, I think, forgive me, just to expand on that a moment, the overall statistics suggest that intelligence in that broader sense has worked to real advantage in conjunction with far better data, passenger manifest information. We have seen the use of Schedule 7 dropped from 60,000 travellers stopped in 5 or 6 years ago down to 17,000. That is in part because of the use of intelligence and greater information. But there is then still a level of complexity as to the circumstances in which an experienced officer applying the codes should be entitled to stop some where he or she wouldn't stop others.
Thanks. Jeremy.
Thank you very much. Following on from that, when I've travelled back to Europe from some destinations which are potentially known for potential criminality or throughput of criminality, such as drugs and other crimes, into an airport like Schiphol, Amsterdam, I've noticed very considerable police and border security activity on everybody coming out of that flight. On similar flights back into the UK, sometimes the same, sometimes slightly less. Do you compare notes with your European colleagues to find out whether our system is similar to theirs in terms of the number of people who are coming from particular destinations or percentage of people from particular destinations who are searched? Is that something that's part of your remit?
I think it certainly would be within my remit, although my answer to the direct question is that I've not yet been able to, as it were, find the right individuals to ask that precise question. There is no independent reviewer sitting, as it were, at a desk like mine in any of the other European jurisdictions. There are some quite similar, French Defender of Rights, to give one example, but actually we have to go to Australia to see a national security monitor whose job description is very close to mine. So that is still work that, thank you, I think I need to undertake, is to look at the comparison between this country and other parts of Europe. What I would say, though, and I'm grateful for it, is that harking back to something I said earlier about learning lessons from general crime and applying them to detecting terrorism, you're absolutely right, as I know as a trial lawyer over 3 decades, that in terms of detecting serious drug importations, that is precisely what the authorities look at, not just in this country but abroad. And it is the individual or individuals who fly back by an indirect route when you would expect them to take a direct flight who are going to be the focus of greater attention. That's a very simple, crude example, but that way of thinking, that way of detection, obviously applies when we come to consider those coming into this country, whether never having been here before but travelling in with terrorism in mind, or those who are commonly called returning foreign fighters, who may be British citizens and who are coming back. The route they take, the mechanism they choose for travel, is one of the triggers which the Code of Practice under Schedule 7 is there to look at, to rubber stamp, and to say, yes, it is appropriate to look at that. Information sharing between this country and other countries is of enormous importance, and I, as it were, don't need to ask any counterparts in Europe in order to know that that already goes on, is hugely effective, and if I may say so, is why, albeit this country has suffered, and particularly last year in particular ways, the incidence of successful terrorist plots has been so low in this jurisdiction, and frankly so late in comparison with other countries who suffered in 9/11 or suffered in 2004 with the Madrid rail attacks, where the first plot that got through in this jurisdiction was as late as 2005. Maybe, as it were, an odd way of putting it, because 7/7 was an appalling event, but the domestic authorities' hard work, fueled by international liaison from wherever in the world, kept us safe for actually quite a long period of time, continues to do so, which is why even in 2017, where there were 4 or 5 plots that succeeded or partially succeeded, the statistics still demonstrate that far more plots and preparatory acts were detected than those that were not.
Thank you.
Joanna.
Thank you, Chair. Good afternoon, Mr Hill. Could I just go back to Doreen's question about Schedule 7 of the Terrorism Act, and this recommendation you've made about the reasonable grounds to support test was of course just made in your annual report, which I think was issued just last week.
Yeah.
Are you able to give us an indication of when you expect a response from the government in relation to your recommendation?
Well, plainly that's a matter for government, and it's not for me to tell them when they must respond. We know that the last annual report, which was David Anderson's final report, was published in December 2016 in relation to the operation of the legislation in 2015, and the government response, which I've cited in my document, was dated, I think, July. Now, there was an intervention of the general election. There were other things happening, which I need hardly mention, a busy time in government, but there was a delay of something like 6 months. If I can express any hope at all, it would be that it should be less than 6 months before the government finds time to look at what I would respectfully submit are modest but sensible proposals and recommendations, and to indicate which ones they accept and which, if any, they don't accept. So sooner rather than later, but beyond that it's not for me to say.
Can I move on to legislation or proposals to treat internet providers as publishers? Now, I think you've expressed some scepticism about the overuse of legislation directed at terrorist offences, and you've also flagged up the dangers posed by online material and the difficulties of getting the balance right between protection and fundamental freedoms such as right to freedom of speech and the right to privacy. What do you think about proposals to treat internet providers as publishers responsible for the material on their sites?
It's a line that we've always drawn back from, and the construction of the Section 2 dissemination of terrorist publications offence in the 2006 Act is very careful. Unusually, there are many sub-clauses within Section 2. It is a complex piece of legislation which tells us that extremely careful thought was given to this area and to meeting this area of criminality. And it was not the view of this place that tech companies, to use the shorthand, should be regarded as publishers. And that remains the case. My answer to your question is, of course, in the light of what's happened over the last 12 months, it is perfectly natural that that is revisited. Of course, we will look with interest at the German experiment, which is now on the statute book there, in terms of fining those who fail to take down. And we will look at any other incipient statutory answers, and I think Australia may be considering one at the moment, although I'm not very conversant with the detail. Not for me to say that Germany and perhaps Australia are getting it wrong, but what I have said is that for a variety of reasons we would benefit from the help that these tech companies can and really should give, and potentially we'd benefit more from their help than from criminalising them, which is what we would be doing if we defined a tech company, an online platform, as a publisher. So the consequences of that redesignation would be fairly far-reaching. It's not for me to say that, using a crystal ball, we will never reach that position, but as it stands, I support everything that's been said by people far more senior than I, to the effect that tech companies must do more. And in my few speeches and writings, I've tried to re-emphasise that message. But I am dubious at the moment as to whether it would be effective to designate platforms as publishers. Why am I dubious about it? Well, a variety of reasons. The material that the tech companies already provide on arrest of persons of interest to police and law enforcement is of the greatest utility. What I mean by that is, in almost any prosecution that I've conducted over the last 10 years, it is the communications chronology, and of course that now means the online communications, that forms the backbone of the case. That evidence that comes from the tech company on an application which is after the fact by law enforcement is a large part of what proves the case. So this material, when it is visible and when it is provided, can be of great use to the Crown Prosecution Service Counter-Terrorism Division and to prosecutors, as I used to be, in proving these cases, and that is what we want to do in these cases. Driving that material underground into spaces where it's far harder to detect would have the consequence that it would be much more difficult to prove these cases by reference to online communications if we can't find them. And that would be counterproductive. Equally, there is an argument that having this material available and in plain sight permits a counter-narrative, a powerful counter-narrative, to be placed, as it were, alongside it online, so that future individuals who may be at risk of radicalisation online may think again when they realise that there is a strong counter-argument to what they may be contemplating. So my answer is that strength in legislation in the online space is just as important as strength in legislation elsewhere. But given that this is the greatest communication platform there's ever been, and that billions of us exist with the benefit of the internet, interfering with it in legislative ways may, in the fullness of time, be necessary, but it would be at great cost, both in terms of the rights infringed and in terms of the practical consequences of unearthing information. And I'd just add to that, because it's important, that in terms of the online dissemination of information, when I say that tech companies need to do more, that is obviously right. We've reached a position where the takedown, in terms of percentage of material taken down, when an alert is sent, when a takedown request comes from the Counterterrorism Internet Referrals Unit, CTIRU, is extremely high. So that is evidence already of communication between law enforcement and tech companies and cooperation from the tech companies. It needs to be 100%, and my understanding, it's pretty close to 100%, certainly in terms of the major tech companies. There may be subsidiary issues with much smaller platforms, much smaller back offices, if I can use that phrase, but that is going well. What is more difficult is to identify the material so it's never uploaded in the first place. And in that regard, we have to have a measure of understanding of the tech companies. I don't speak for them, but whereas I was talking about learning lessons from general crime, whereas we all know that over the last couple of decades there's been great success in identifying pornographic images of children and ridding the internet of those sort of imagery, that is because, firstly, of goodwill, but secondly, because we can all identify a pornographic image of a child. That is not difficult. What is much more difficult is to identify terrorist propaganda as opposed to material that expresses a view that many would disagree with, but actually doesn't fit the Section 1 terrorism definition. So it is difficult to deal with this in terms of avoiding the material being put up in the first place. More needs to be done. It's law enforcement who should be leading the field in this. I'm not entirely comfortable with the notion that private corporations, although they have very deep pockets, should be the arbiters of what's online solely. There is a role for law enforcement applying the statutes that Parliament passes, which mustn't be undermined. But we have to move forward together. So, coming back to the start, forgive me for perhaps taking too long, I can understand why Parliament didn't legislate against the tech companies by describing them as publishers, and I can still see good reasons why they should not be described as publishers. But this debate is not closed. It's very much a living debate, and in part it will be assisted by the foreign experiments that we see over the next months and perhaps a year.
Thank you. That's a very full and extremely helpful answer, if I may say so. I wonder if I can lead you into some territory covered by your predecessor, David Anderson, QC. But I want to caveat that by saying if you don't feel happy about answering these questions, because I'm going into the territory of surveillance and investigatory powers, if you don't feel comfortable with answering them, given the remit that you've described, then please do say so. But I think we would all be very interested to hear your views on the Court of Appeal's ruling yesterday in Tom Watson's case about DRIPA, particularly as you've already spoken, I think, in your Tom Sargent Memorial Lecture about the tensions between balancing rights such as freedom of speech and the right to privacy with necessary precautions against terrorism and serious crime. Now, as I understand the Court of Appeal judgment, I'm afraid I've only skim-read it, so I'm relying on commentaries rather than a full appreciation of the judgment. But as I understand it, there's two big issues here. One is the lawfulness of DRIPA, because it doesn't restrict access to confidential personal phone and web browsing records to investigations of serious crime, and there's therefore an issue about the definition of serious crime. Now, some of us were involved in extensive debates in the last Parliament about the definition of serious crime in the Investigatory Powers Bill or Act as it is now. And you'll be aware that the definition given there is conduct involving violence or resulting in substantial financial gain or a large conspiracy which is punishable by more than 3 years. But I was interested to contrast that with the guidance put out by the government in relation to the European Court of Justice's comments on DRIPA towards the end of last year, when the current Home Secretary, in fairness to her, proposed some reforms to the Investigatory Powers Act in relation to that decision. And she talked about serious crime being defined as including just about everything other than summary offences, such as traffic offences. And there seems to me to be a difficulty here that we've got two different definitions of serious crime. Now, I just wonder, do you have any views, drawing on your experience to date, of what the appropriate definition of serious crime should be, having regard to what the court said yesterday?
Well, I'm going to mention remit in the first part of this answer, because although my predecessor, I dare say, because everybody knows it, was of invaluable assistance in the pre-legislative scrutiny for the Investigatory Powers Bill as it then was, that was a special request to him beyond his remit as independent reviewer, and it's not part of my remit. Watson, which came out of the CJ, the European Court, 3 months before I came into post, was part of the territory, but it's strictly not part of my territory. I'm very anxious that the Investigatory Powers Commissioner, Sir Adrian Fulford, is the man in the best position to deal with these sort of issues. And I've, of course, had conversations with him to that effect. Can I say anything about Watson? What I would say is that it didn't come as a surprise, I suggest, to anyone at the Home Office or in government when the Court of Appeal gave the judgment that they did on Monday. It was quite evident from December 2016 that whether you agree with it or not, what the European Court was saying was going to require some revision of the Investigatory Powers Act, even accepting that actually that legislation is about DRIPA, the Precursor Act, as you've already mentioned, but the principles still carry through. So no surprise that the Court of Appeal has had a view to express. The need for robust independent authorisation is, if I may say so, plainly sensible and necessary. I think it's going to be called an Office of Communications Data Authorisation, OCDA. So that's a new vehicle. We'll have to see how that comes into force. But that answers the independent scrutiny at the authorisation stage point that the European Court was addressing. So that is to be welcomed. In terms of the definition of serious crime only, if I dare say so as one lawyer to another, I entirely recognise that there is a difficulty in placing the bar so low that, as I think the proposal is, serious crime means anything which is punishable with 6 months imprisonment or more. It's undoubtedly crime. That would equate in England and Wales to the distinction between summary offences dealt with in the Magistrates' Court and those which have to be referred to the Crown Court. So it's perhaps understandable that that is a dividing line which has been recognised. Essentially, we're not dealing with Magistrates' Court material, we're dealing with Crown Court material. Whether that is enough, whether that is high enough, I can see that there needs to be an anxious debate about that, but it's not one for me to lead. The other aspect of the European Court decision is that although what the European Court said has been enshrined in this Court of Appeal judgment in its various ways, the European Court itself didn't indicate the application of the principles they identified in national security cases, and that is absent from the December 2016 judgment. So in my area, when I am within remit, it's the national security imperative that is uppermost. Looking at it through that prism, of course I would recognise, as a lot of other people do, that the acquisition through proper means, with independent scrutiny at the point of authorisation, to bulk data in certain types of activity is undoubtedly of great assistance to the authorities, and as much as possible we should ensure that that gets through, that remains within the capability of the security services, subject, as David put it, to the question of trust that we all hold in those who are vested with the material. Of course, the practical ramifications of bulk data, even drilling it down in the ways that the European Court and now the Court of Appeal have applied, is that the authorities are going to be in possession of vastly more about a small number of us. They will be the custodians of that information, and no doubt there will be resource implications in terms of having to look at that material and work out what they really have. Not for me to express any view on resource. But what I am saying is that for good reason, the government set about several years ago trying to ensure that the investigating authorities did have access to bulk data where it was of real utility in cases of need. I leave open the question of whether it would always be a case of need where we're talking about an offence that lawyers would recognise as being actually pretty low down the calendar, whereas a case of need in the higher orders, and certainly in national security investigations, is abundant.
You mentioned this new vehicle the government are thinking of setting up to deal with the second part of the Watson case, the OCDA. Now, my understanding is that the government's proposal was to create an entity within the existing Investigatory Powers Commissioner's Office to carry out authorisations. Now, as you know, the existing Investigatory Powers Commissioner's Office is already charged with independent oversight of the use of surveillance powers. Would you recognise any tension between having the authorisation and the oversight carried out within the same body?
The temptation to comment on that is one that I'm going to resist for the very good reason that is Sir Adrian's territory. It's particularly notable that we have such a senior and independent judicial figure who has constructed and is running the office. It's a matter for him to grapple with, and I wouldn't trespass on his territory.
Okay, thanks very much.
Well, thanks very much, Max. I think you've been an absolute masterclass in openness and clarity, and thank you very much indeed for that. And we look forward to engaging with you and your help and giving us evidence in future inquiries. But thank you very, very much indeed. And we're now ending the public session, but the committee will stay, if you would, just for a few more matters.
Thank you very much.
Thank you. The proceeding has ended. 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 The proceeding has ended.